Hello everyone, today we will be talking about use of force. This presentation will basically be a basic introduction of use of force in international laws and how states can use their force in order to intervene in the actions of other states and whether they can do that or not. So let's start with the brief history first. First of all, before 16th century, what used to happen was wars were a mean of reparation of illegal acts. So whenever there was some illegal acts, states used to wage war on the other states. And then states also used to wage war due to religious reasons, to spread their religion or to suppress other religions. But during 16th to 18th century, there was actually no limit on going to war. So if a state wants to go on war with another state, they can freely do so. There wasn't any restriction. The sovereignty of state was not established, and so on. However, after 19th century, when World War I happened, this tradition was changed, and there was actually concept of state sovereignty that was introduced. And then there was also a concept of territorial integrity and political independence. So the concept basically was that every state has their territorial integrity and they are politically independent, and no other state has right to intervene in these rights of the other state, and a state cannot just go on and wage war on the other state. And because of this, it was stated that the state cannot actually freely go and wage war on each other without any superior authority or without any motive. The main authority that regulates the use of force is the article of UN Charter. The main article that we will be discussing here is Article 2.4 of the UN Charter, which actually restricts the use of force, and it reads as, all members shall refrain in their international relation from the threat or use of force against the territorial integrity or political independence of any state. So this article is basically establishing the territorial integrity and political independence of the states and restricting the other states from using threat or use of force in order to intervene in other states' matters. Now, what does threat means? There are several debates on the interpretation of the word threat. It can be any statement, it can be any provision, it can be creating an economic situation or a political situation that can actually threaten the other states and their integrity or sovereignty. And that shows that force will be used to compromise the sovereignty of the country. So if it's a statement that shows that the other states' sovereignty will be compromised, or if there is if an economic situation is created that shows that other states' integrity or the sovereignty will be threatened, then that can be considered as a threat. And let's look at an illustration of it. When Saddam Hussein attacked on Kuwait, it was considered against Article 2.4 of the United Charter because it prohibits the attacking, occupying, and harming of other states. Now, there are some exceptions in which states can actually use force. Let's look at those exceptions. The first one and the most important one is self-defense. So when a state has to use defense, then they can use force. And the second one is action by Security Council. The third one being humanitarian intervention. And then the last one being consent when the state itself allows it. We will be looking at each of these exceptions in detail in the following slides. First one being self-defense. Article 51 of the UN Charter regulates self-defense, and what it basically entails is that it is an inherent right of individual or collective defense. So it can be exerted by one individual state or it can be exerted by a group of states until the Security Council has taken necessary measures to maintain the international peace. And if force has been used under this particular article, then it has to be immediately reported to the Security Council. Now, there are several interpretations of the word armed attack that has been used under this article. There are two basic approaches. The first one is literal approach. What it means is that armed attack will be considered when an army is physically attacking a state. There are several criticisms of this approach, that when there is a physical army at your border, then how can you prepare yourself for the self-defense? So that branches out the other approach, which is the loose approach. It includes the anticipatory defense. What it means is that the armed attack is anticipated, and it does not have to be physically or immediate in the moment. However, when we are talking about using self-defense as for the sake of use of force, it has to be immediate. For example, the threat has to be immediate. Otherwise, there would have been an option to going to the Security Council. So if the option of going to the Security Council is open, then the use of self-defense cannot be, then the defense of self-defense cannot be imposed. And there must be a response in some attack. So the state which is using self-defense has to be a victim. Self-defense in itself is subject to restraints, which is necessary and proportionate, which means that self-defense has to be necessary and it should be proportionate to the attack that was put on the state. Now, when force is used as self-defense, then it needs to be immediately reported to the Security Council, and the measures that were taken under this defense also needs to be reported. Exception of this particular provision is Article 52, where if the states have a regional agreement between them, then that incident will be reported to the regional authorities rather than directly to the Security Council. Right to self-defense is life until Security Council takes an action and makes a peaceful agreement. So when a Security Council intervenes and tries to make a peaceful agreement, only then after that the states cannot make a defense of using force in response to self-defense. Then that right actually stops. Now coming towards anticipatory self-defense, when a state suspects or anticipates an attack, then it can be taken as self-defense. This is what we call anticipatory self-defense. However, anticipatory self-defense itself poses certain questions. One of the most important one is, on what grounds do we understand that the anticipatory self-defense that was used was on the right parameters or not? For that, we need to look at Caroline test. In Caroline case, what happened was that there was a US steamboat named Caroline, which was carrying arms for the aid of Canadians against Britain. So Canadians and Britons were having war, and US was aiding Canadians in that armed conflict. Britain attacked that ship and causing it to blow up, and eventually it fell into the Niagara Falls. Now, the argument that was posed by Britain was that they attacked the ship because in response of as a self-defense. So this case then established the main principle in determining what it means to take self-defense in case of use of force. So this case then established Caroline test, but which is stated as when an attack is immediate, leaving no moment of deliberation and no choice of means. So the two distinct principles that this Caroline test then establishes are that the use of force must be necessary because the threat is imminent, and thus the peaceful alternative is not an option. So the threat has to be imminent and the use of force has to be necessary. So this established the principle of necessity, that there was no other choice other than using force. The second principle then is the response must be proportionate to the threat. So it also established the principle of proportionality, that the kind of force that was used by the attacker should be proportionate to the force that the victim is using as a self-defense. Now we see application of Caroline test in oil platform case 2003. In this case, there were certain Iranian missiles that hit US vessels. In return, US attacked certain oil platforms in Iran and destroyed them. This matter then went to the International Court of Justice, where the court held that the attack by the US was neither necessary nor proportionate. The first step that the US should have taken was to inform Security Council about this attack, but US failed to do so. Moreover, the US did not resort to peaceful means under Article 33 of the United Charter. That should have been the first step of the US. After establishing these principles, the ICJ goes on to hold Iran accountable for the attack on the US. Now, the second exception of using of force is when Security Council takes an action. Chapter 7 of the United Charter determines the authority of the Security Council in using force. The main articles that regulates this authority of Security Council is Article 39, 41, and 42. In Article 39, it actually establishes the power of Security Council to determine if there is an existence of threat, act of aggression, or breach of peace, and then make provisions accordingly. Article 41 of the UN Charter deals with the actions that Security Council can take, and there does not necessarily have to be an armed force, a use of armed force. So Security Council is not actually required to go and wage war on the other state. Security Council can adopt other measures as well. For example, interrupting economic relationship, means of communication, and so on. Under Article 42, the instances where the Supreme Court can actually use the actual force, which means the armed force, is in maintaining the international peace and security. Now, there are some examples, and we can see where a Security Council used force in order to restrict the other states from attacking the sovereignty or integrity of the certain states. The first example that we have is of Kuwait, when Iraq intervened in Kuwait and started waging war and trying to take over Kuwait. That is when Security Council intervened and tried to stop Iraqi forces. The next example that we have is of Haiti, where Security Council restored democratically elected head of the state and then tried to make peace in that state. The last example here we have is of Rwanda, in which Security Council intervened in order to terminate the genocide. The next exception that we have in using force is humanitarian intervention. So when there is a big or a major human rights threat, then Security Council can intervene and use force in order to stop that threat. The examples that we see in which Security Council intervened based on human rights grounds are Somalia and Bosnia, where they delivered humanitarian assistance. The last exception that we have is consent by state. That is, when a state itself consent with the use of force in order to eliminate or make peace during an internal conflict, only then the other state can intervene and then use force. So these are the four exceptions to the use of force. Generally, these are the cases. The most important one is self-defense, and these are the cases where it is primarily preferred that the Security Council is involved and a Security Council actually makes peace during the armed conflict. Thank you. That's all from our side.